So I'm going to talk briefly about the Communication Management Unit, and mostly give you an update on where things now stand with our case challenging this unit. So I think most people in the room know that Communication Management Units, or CMUs, are two prison units within the Federal Bureau of Prisons, which were opened in 2006 and 2008 as a way to sort of segregate prisoners within the Bureau of Prisons who the Bureau of Prisons wants to keep from accessing the outside world, and to sort of limit their influence on other prisoners within the general population. Since the units have opened, they have always been filled with Muslim prisoners, not exclusively, but majority of them. So for example, during the years we were tracking the population in the units generally were between 60 and 70% Muslim. That's compared to about a 6% population of Muslims within the Federal Bureau of Prisons. So it's a huge overrepresentation. And the government has always defended that overrepresentation by saying it's because the CMUs are primarily designed to hold prisoners who've been convicted of terrorism-related offenses. But when we actually look behind the numbers, that does not explain the overrepresentation of Muslims within the unit. So for example, 10 of the first 55 men who were sent to a CMU were sent there not because they had convictions related to terrorism, but because they had violated rules about communications within the prison system. And of those 10, 8 of the 10 were Muslim. So even when we're looking beyond the universe of terrorism-related cases, we still see this huge overrepresentation. The Center for Constitutional Rights, where I work, filed a lawsuit challenging the CMUs back in 2010. And we originally challenged them on several different grounds, arguing that they violate equal protection because of the overrepresentation of Muslim prisoners, that the restrictions on communication within the units, especially the ban on all contact visitation, was cruel and unusual, and that the units violate due process. The district court dismissed all of our claims except for the due process claim and allowed that claim to go forward. And that's the claim that we've really been litigating over the past 8 years. So we engaged in a couple years of discovery in the case where we got all sorts of documents from the other side, the Bureau of Prisons, and we were able to depose lots of prison officials. And we built a really extensive record of evidence about how individuals are selected for CMU placement, how they're reviewed from the CMU once they're put in those units, and about who's being placed in these units and why. We then moved for what's called summary judgment, right? We asked the court to rule as a matter of law that the units violate due process based on the evidence we were able to amass. And we lost in the trial court. The trial court held that prisoners don't have a liberty interest in avoiding placement in a CMU. So this requires backing up a minute and talking about sort of what due process requires. Anytime a prisoner challenges placement in a particular unit or being subjected to a particular restriction, there's a two-part test that courts will use. The courts first ask, do these prisoners have a liberty interest in avoiding placement in the unit or avoiding the restriction at issue? And they determine if a prisoner has a liberty interest by asking if what's being done to that individual is atypical and significant compared to the ordinary instance of prison life. So is this a lot worse than what you could normally expect to experience in prison? And if it is, that means the prisoner has a liberty interest in avoiding that kind of treatment. Once a prisoner has a liberty interest, at that point the court will look and say, okay, well, are the procedures that were used to send this individual to this unit, in this case to send them to the CMU, do those procedures provide adequate protections, right? Are they fair? Do they mean that people won't be sent to a CMU or somewhere else arbitrarily or sort of discriminatorily? So you only even get to that question about the types of procedures used if you show the person has a liberty interest. If it's no liberty interest, The prison can put anyone they want in the unit for any reason at all, and the courts can't scrutinize it. So after we lost on that initial liberty interest question in the district court, we appealed up to the DC Circuit Court of Appeals. And we won in the reversing the liberty interest ruling from the lower court. This was about 2 years ago. The DC Circuit ruled that prisoners do have a liberty interest in avoiding placement in a CMU because of sort of the duration of CMU placement. The judges looked at how long individuals were spending in the CMU, and it was years for some people, 4 or 5 years. And the court said 4 or 5 years, without contact visitation, with limited phone calls, that's really significant. That's a big difference from what you normally experience in prison. The court also looked at how unusual CMU placement was. Only about 1,000 people had ever been considered for CMU placement at all, and almost all of them have been sent there. And that's despite, thousands and thousands and thousands of people within the Bureau of Prisons who were presumably eligible for placement in the unit under the sort of criteria that the BOP had developed to decide who was in there. So because so few people were even being considered, this is like this really unique thing that's happening in the prison system. And when you have something that unique, especially when the result is an overrepresentation of sort of a minority religious group, this goes to show why procedures are so important, right? Because it suggests that people are being singled out for unfair reasons, for discriminatory reasons. So the court held that prisoners do have a liberty interest in avoiding placement in a CMU, and then the court sent the case back down to the district court to say, okay, now that we've made this ruling, you have to look at the procedures the Bureau of Prisons is using, and determine if they satisfy due process concerns. So that happened about 2 years ago. The case was sent back to the district court. And so the district court had in front of it all the evidence we had gathered about why the procedures that the BOP uses violate due process. And we've amassed quite a bit of evidence. I think it's really strong evidence. So there's sort of 3 components of what courts have held is required for due process. First, a prisoner has to receive notice of the reason that he is placed in a CMU. And what we are able to show is that the notice that is given to a person after they're sent to a CMU, it doesn't actually, it includes sort of short reason why they were sent to the CMU. It's supposed to be the reason they were sent there. But what we were able to discover is that the reason written on the notice that the individual gets isn't the decision maker's reason, right? So the decision maker, the person who actually decides who will be sent to a CMU and who won't, doesn't write down his reason anywhere. He just doesn't write it down. The reason that's listed on the notice of transfer is the reason that counterterrorism unit has recommended the prisoner be placed in a CMU. And even worse, the counterterrorism unit has a habit of not writing down all of their reasons. They just write down like one reason why a person is sent to a CMU, why they are recommending that the person go to the CMU. And when we ask them, well, why don't you write down all your reasons? Their only response was, there's not that much room on the floor. So in other words, someone in the counterterrorism unit in the Bureau of Prisons could recommend that an individual be placed in a CMU for like 3 different reasons, maybe one of which is that it has protected speech within prison. The fact that he's talking about, what's happening in the facility he's being held in ways that are, completely in accordance with the prison's rules. So maybe, there's 3 different reasons, and one of them is sort of like not a fair reason for the Bureau of Prisons to be considering. The CTU will write down one of those reasons. The decision maker for CMU placement will decide that this person's going to go to a CMU for a whole other reason altogether, and the prisoner's never going to know why they were actually sent to this unit. So even that's kind of one of the first and the most fundamental due process problems we found when we looked at CMU placement. But there's a lot of other problems. Due process requires that individuals who are sent to a restricted unit have a fair opportunity to challenge the factual basis for their placement before like a neutral fact finder. So, for example, if your notice of transfer if the prisoner's notice of transfer says, okay, you're sent to a CMU because your crime of conviction included speaking in code, and we're worried that that makes you a particularly dangerous person within the Bureau of Prisons. And maybe the prisoner looks at that form and says, well, that's not true. My crime of conviction didn't involve speaking in code. And I have evidence to prove it. I'll give you my sentencing report, all these different documents. We were able to discover that there is no avenue for the individual to challenge factual discrepancies in their notice of transfer. The only hearing process available to individuals sent to a CMU is the Bureau of Prisons administrative remedy process, which I'm sure some of you are familiar with. It never results in any relief whatsoever. In fact, we were able to get the Bureau of Prisons to acknowledge that when they receive complaints through the administrative remedy process about CMU placement, what they do is they review the reason that the prisoner has been sent to the CMU and remind the prisoner of that reason. They don't take a second look and decide whether the listed reasons are accurate or not. So that's no review at all. Finally, the process requires that individuals who are placed in restrictive units receive periodic review of their placement to see if they can be moved out to a less restrictive unit. And what we were able to show is that the first 3 years that the CMUs were in existence, there was no review process whatsoever. The Bureau of Prisons was lying, flat out lying, telling prisoners and others that individuals would be reviewed every year and a half for transfer from the CMU, but we didn't even have the procedures in place yet to do that. After we filed our lawsuit, the Bureau of Prisons did create a procedure to review people for movement out of a CMU, and those reviews started and transfers started. But that was only in response to litigation, and even now, problems with the reviews continue. So we were able to show that even though the Bureau of Prisons' own regulations require that individuals who are denied transfer out of a CMU at one of the reviews be given an explanation of why they're denied and notice of what they need to do to change their behavior to earn release for a CMU. What we were able to show is that prisoners aren't getting those kind of notices at all. They just get a form notice saying, we've determined that you need to stay in this unit. So all of that evidence, we put all of that evidence before the district court judge. And then we waited. And 2 years later, we are still waiting. This is not that unusual in federal litigation. Sometimes judges take years and years to decide major motions. 2 years is a really long time. I've had cases where we've waited longer, but 2 years is a long time. And in the meantime, what's happened is that all of the individuals, all of our plaintiffs, from when we filed the lawsuit, have finally now been released from Bureau of Prisons custody. This is, of course, a wonderful thing for them, but it also means that the government can argue that the case is now moot because there are no longer people within the Bureau of Prisons who face placement in a CPU. We have argued that the case is not moot, that the court needs to rule on the due process claim, even though our clients are no longer in the Bureau of Prisons, because the information about them that was compiled by the Bureau of Prisons through these sort of unfair and unsafe procedures, including sort of erroneous factual information developed to send them to a CMU, that information remains in DOP files, and it remains in our clients' records, and it could be used against us in the future. Like, for example, if one of our clients wanted to seek release from probation, that evidence might come into consideration. If someone wanted to seek a pardon, that evidence would come into consideration. So we've argued that until the erroneous information is expunged from our clients' prison records, that we still need relief, and the court still needs to review whether a CMU procedure is violating due process. But this is this is an optical argument. Most of the time when courts consider claims by people in prison who have since been removed from prison, have been released from prison, the courts dismiss those cases as moot. So we are very concerned about what will happen in the coming months. The government has not yet moved to dismiss the case based on our client's release, but We think it's likely they will do so soon. And we're concerned about what's going to happen. One sort of plan we have is just to make sure that, if our case is dismissed, that we find partners to continue monitoring what's happening in the CMU. I do think that the Bureau of Prisons has fixed some of the problems with the way they send people to the CMU and the way they review people. It's not enough, but they have done some. We're concerned that things will get much worse if our case is dismissed. That once the Bureau of Prisons knows that this case isn't hanging over its head and has been hanging over its head for so long, that the government will feel, even more free to send whomever they want to this unit for whatever discriminatory reason they want. And of course, under this administration, that's an even greater concern. So that's where things stand now with our challenge.
Kathy, I want to thank you for the tremendous work. I've known Kathy for years, and the way we met is by me sending her people who are being harassed by the FBI in Western New York or in the greater New York area, and she, An Albany in one case, and she's sending the FBI running. It's really a tremendous honor to be here today. Honestly, I didn't come to share any knowledge, but rather to just get benefit from being in all of your company and offer you our support and let you know that we are with you. It's really an honor for me to be here with all of you today, and I apologize I couldn't be here for the whole day. I'd already committed to another conference, but I wanted to make sure to at least get a little time with all of you and let you know that really we all have to stand united, that the injustices you have faced and your families have faced are an injustice to every person in this country. It is an injustice to all humanity. And one of the verses in the Holy Quran that gives me hope, وَلَا تَحْسَبَنَّ اللَّهَ غَافِلًا عَمَّا يَعْمَلُ الظَّالِمُونَ. Don't think Allah subhanahu wa ta'ala is unaware of what the wrongdoers do. And of course, being in my position, I think it's very difficult to share any insight about bearing with patience difficulties. Nonetheless, for what it's worth, I'll share a few ahadith that inspire me and give me hope, because while alhamdulillah Allah's preserved me from facing it directly, we've worked with many clients that have been through traumatic injustice. And one of my favorite ahadith, Rasulullah said, the first people to enter paradise and those who enter paradise without questioning and reckoning are those who thank Allah in times of difficulty and in times of ease. And of course, what is more difficult than having family members torn apart, locked up, put in CMUs, as Brother Hatim suffered and faced, and yet the ability for people to stay strong on their faith in such difficult times is something that truly will pay off eternally. I remember one of the Syrian refugees, he said, "Ma dal ma'ishi," I've lost everything. He had swam across the Mediterranean. I've lost everything, my home, my family, my wealth. Ma'i dini dal bas, only my faith remains with me. Why jua, it is inside me. And really, they can take anything away from us, but the only thing that cannot be taken away from us is our faith and our resolve. Bodies can be conquered, but hearts and minds cannot, really. And that is the greatest thing we have, I truly believe, is our faith. And it is the only thing that can never be taken away by force. Which brings me to the main point that I wanted to emphasize, and that is that we really, as believers, believe that Allah subhanahu wa ta'ala, God, the Creator, the most merciful, He never takes, He only gives. So every loss, every tragedy is truly an opportunity for something better, as difficult as that may sound. And that's where the trust and the faith in God comes out. And I think the opportunities in these injustices that have been faced is hopefully that we all commit to stand strong, seeking justice for our loved ones, but also challenging other instances of injustice, not allowing ourselves to be defeated, not allowing ourselves to fall into hopelessness and despair, but rather letting the injustice that we have faced inspire us and be our fuel to push back even harder and to prevent others from feeling the pain that we have felt. And therefore, through some tragedy and personal tragedy, maybe we can be a source of mercy for countless others. And that requires having faith trust in God's plan and having each other's support. So anyway, I apologize I cannot be here for too long, but I want you to know that inshallah is just the beginning of a relationship. You can always count on us. We'd be happy to host you in Florida as well and in Tampa, inshallah, and let's continue the conversation and know that inshallah we will stand united, and whatever they throw at us, we're going to throw it back at them 10 times more, inshallah. Assalamu alaikum wa rahmatullah.
Thank you, Hassan. I'm glad you could be here even for a little while. I wish you could be here longer, but we will continue to work together. Thank you. All right, so
Maybe we let Hassan answer questions if anybody has
I
any?
can answer. I can stay for 14 more minutes. So.
Okay, so I guess if people have some questions for Hassan in particular, then we can go ahead after that with the rest of the workshop. No? No? All right.
I have a question.
Yes,
Was it, were you at the other event in Alexandria this weekend?
Yes.
And so I remember seeing that it was about justice. So I was wondering if from the parts that you were at and participated in, just stuff that the coalition is of course talking about, the stuff that our family members are concerned with, our family members are affected by. Did the Conference of Justice speak about our issues?
Sure, so that's a great question. I was not in all the sessions, but generally I believe the themes and the message is very complementary. And I think an offline conversation could be had about, you know, how we can maybe put a little bit more unity between the two. But this is all the same, I think, problems in the United States in particular. So one of the terrorism cases I was involved with, they were trying to give an imam 20 years in jail, that he was a terrorist, and the only evidence they had was his possession of Islamic literature and possession of books that the government didn't like. Nobody was willing to go and sit in his trial. Alhamdulillah, finally then I went and sat in his trial and I audited the government's testimony, and I was able to see how the government's testimony was complete rubbish. You know, you don't even need a associate's degree in Islamic science to know that these guys don't know what they're talking about, or political science for that matter. I mean, really, it was just so off. So alhamdulillah, we were able to testify, and the imam had been in solitary confinement for almost 3 years. Alhamdulillah, they released him back to his family, and he didn't get that 20-year sentence that they were trying to give him. But what that opened my eyes to the fact is that we really need to be proactive in our ability to monitor these cases and hold the government accountable when they cross the line. And I really believe in that particular case that I'm talking about in Orlando, had we not been present, he could have gotten that 20 years. And every time he sees me, he cries. He says, you know, if you guys weren't there. And for a long time, the Muslim community has been very afraid to be involved, afraid to get out. So, and it still is. So there's a lot of work to overcome. I would say a lot of this depends, you know, on grassroots level relationships and local relationships. And I think frankly, I think a lot of it, some of it is fear, some of it is just being overwhelmed with just so many, you know, fires trying to put out, trying to prevent the next person from getting locked up, trying to keep up with the influx of FBI interviews that we're getting requests for. But I think there's a lot more room that can be done to stand with you and support your cause, which is really all of our cause together.
Yeah, I think, sorry, I'm just going to ask one more question. I think that I remember seeing the speakers for the weekend, and they're such prominent figures in the community. You know, it's almost like celebrity level. Right? I mean, this is someone from outside
No, it's true.
looking in. But so I just know that, and I hope I'm speaking on behalf of the group, what we wish is that people who are prominent leaders in the community that our families are affected by are speaking clearly about what is a huge, the biggest civil rights, human rights issue in the community that those leaders are representing.
So one thing I can commit to, and I'd have to speak to the organizers to see what's been done in terms of efforts to arrange this, but at the next conference perhaps, and if Brother Hatem really stays on my case and makes sure we're engaged on this, I can definitely reach out to a lot of those individuals that are very well known within the Muslim community and make sure they're participants in the next one, and try to get at least 4 or 5 well-known names on the national scale, inshallah, here.
Not even just here, but in your conference about
Right.
justice.
No, and I think they do hit those points, but I think it's different when they engage with families and hear the stories and offer support locally.
Thank
Very good. Sister, with that question?
Assalamu alaikum, sir. I'm really thanks a lot. I'm here today to notice this change history. When they arrested my husband 13 years ago, I was in Doha, Qatar. I called the resident of CAIR. I told him this and that happened to my husband. This is first people I told. He told me sorry, we don't get involved in crime cases. I remember, so that time I said CAIR never care. But today really, thank you, and I'm very happy that you change or CAIR change their work, because really all of the Muslim organizations need to be one hand, one union to face all of this.
Well, thank you for that insight, and we'll get you in a second, inshallah. The problem is that we're still essentially in the first generation of developing these institutions. So 13 years ago, maybe there was 1 or 2 attorneys in the whole CAIR family. If even that, there may not have even been any. Honestly, back 13 years ago, there may not have been any attorneys within CAIR. Now, alhamdulillah, across the CAIR family, we have about 50 attorneys. And we're pushing the change. So CAIR Florida, I would see it as a chapter that pushes change. We were one of the first to get involved in immigration assistance, because that's used heavily right now to target people and go after people as immigration. And we were the first to get involved in criminal defense within a very limited scope. And I still think, the MLFA and the Center for Constitutional Rights is, I think, at the forefront of criminal defense, and we've partnered with them, we've sent them cases. But I'm also appreciative that we've been able to build our capacity where, at least on state criminal cases, where it's a clear discrimination bias, we've been able to get involved, and even in that federal case that I mentioned. So I think as our community grows and matures, we're going to be able to be stronger and more effective, but we need people to be more proactive. And the issue is, frankly, we need people to understand that it could have been their husband, it could have been their son, their father. And if they don't believe that, if they don't feel that, then they're missing from the faith. They're missing, their faith isn't complete if you don't feel the same pain when your sister's husband is taken, or your brother's than your own. So this is the problem. We need people to wake up and recognize and invest proactively so we can get there. Yes, sister.
Can you tell me what links the CAIR chapters to, I guess, a national organization, and how you differentiate yourself from other CAIR chapters? Because from what I know, CAIR still does not terrorism-related.
Sure. So it's a great question. And I'm here on behalf of CAIR Florida, speaking on behalf of CAIR Florida at the invitation of my Florida leader, Brother Hatem, may Allah bless him, and Sister Mel, and our friend Kathy. But CAIR is a federation, right? So what does that mean? I mean, we see it as a federation, which means there's a lot of autonomy across the chapters, there's a lot of diversity across the chapters. The CAIR National Office here in Washington, D.C., and our CAIR Florida is almost at that size, if you're talking about stuff. CAIR Florida is probably one of the biggest from Florida to DC and from Florida to California. So in our ability to run the organization, we've been able to take on cases. I think CAIR National focus still hasn't been there, and there's focusing right now really heavily on the watch list cases. They just exposed the government in a huge lie and deception in the most recent lawsuit, where they asked the government, in a lawsuit that I've been a part of, do you have programs that monitor travelers while they travel and spy on them? And the government denied it. And then the Clear Skies program came out in the news, and the judge was really outraged. And we're making progress in that case. So they're facing from another perspective. But again, the problems and the challenges we face, I believe, is too much for one organization to handle. And that's why we're very grateful. You got MLFA that on a national level, and the Center for Constitutional Rights that does handle those kinds of defense cases. Yes.
As a follow-up question, I'm going to be very straightforward.
Yeah.
That I've been very disappointed with Muslim organizations, including certain CAIR chapters where I was publicly. So I'm a sister of Ahmed Abouhadi, and my brother's case was one of the very first cases back in 2003 where he was illegally detained in Saudi Arabia and then brought back and charged with terrorism-related charges based on a false confession of being for torture. And honestly, we've been, completely let down by every Muslim organization, and the only ones who have come to our defense are, non-Muslim organizations. And I'm not just talking about organizations, but even individuals of prominence. I have church leaders and rabbis and atheists who are more supportive to us than our Muslim brothers and sisters. And so, when I have a CAIR chapter, one of the largest CAIR chapters, I'm not talking about
utterly disappointing that, here we are more than 15 years after 9/11, and our organization still do not address these issues. And she tells me, my heart breaks for cases like your brothers, but we do not have the resources. That's honestly adding insult to injury, because you guys have some of the biggest resources amongst Muslim organizations. And it's just utterly disappointing, and it feels like a betrayal that, we're still considered fringe, and our cases are not listened to, and no one comes out to our events, and no one gives us donations, and we are just ignored. And I want you to bring this to the attention of other prominent community leaders, because we're completely ignored. At this point, it's reached to the point where I'm questioning my faith, because my brothers and sisters are not supporting us.
Well, and I think that's why, to the earlier point about bringing more people and having a different presence here, especially from a lot of the different maybe chapter leaders, prominent speakers across the country, to actually meet with the families and have that one-on-one may go a long way. Not that my apologies were worth anything, but I definitely want to apologize for all the victims and their families, because the truth of the matter is I don't believe we as individuals or as organizations or as a community have done enough. May Allah forgive us for that. We have a lot of work to grow in that area. I will say to give a pragmatic answer, unfortunately, as well. I graduated law school in 2011, and I moved down to CAIR, Florida. I was the only full-time staff member. Since then, we've grown from just myself now to 27 staff and 8 attorneys. But the point is, when I'm running the largest Muslim organization, one of the largest in the country, and I see how little support we have relative to the mission and relative to our adversaries, I'm extremely troubled. Frankly, somebody in my position should have a Rolodex of billionaires funding the effort, because that's what other communities do. But when you run a large and you don't even have one, then it's a problem. And I will say this, again, nothing can I think we've fallen short regardless towards you and towards others. But that point aside, the truth of the matter, I say this very frequently within our community. I say, we're given this much resources to do this much work, and then people are not satisfied when we do this much, So I still think with being on the ground, our organizations are giving back to the community a lot more than we're taking. But we need a lot more support. We got to up the game. And, may Allah accept from us to establish those institutions where the next generation doesn't have these struggles and these complaints that you so rightfully do today.
And I think just the most heartbreaking part about it is that, here we are so many years later, and I still see new family members come to every conference where their loved ones are being entrapped, and it's how have we not created this awareness in our community?
That's a great program. So one of my focuses, and I'm willing to come out to local communities, do this in local mosques, local community centers. The problem is sometimes people who are targeted don't necessarily frequent those centers, but my focus since I joined CAIR Florida has been on FBI entrapment. So alhamdulillah, gone to dozens and dozens of masajid across the country is speaking about FBI abuse and how that leads to entrapment and how to protect against that. And any opportunities there are for us to continue this message and to proactively prevent, alhamdulillah. And I really, one of the things I'm very grateful to Allah for is that I know for a fact there have been a lot of people who were cornered by the FBI or harassed. Alhamdulillah, because they reached out to us and listened to our advice early enough, we were able to prevent so many more families from being here. And Kathy's done an amazing job, because whenever anybody in the New York area I'm able to send it to her, she's done an amazing job taking care of them. Alhamdulillah. And we have our work cut out, and we're committed.
Yeah, we're
Yes.
we are very gracious for what you said, the work you do. We are very gracious for that. I hope that maybe someone like you who is coming here, who is speaking on our panel, and like you said, going out and speaking, can help influence some of your peers on that level to join you in a unified message, so it's not just you or someone every now and then that hopefully you can influence on a higher level of your peers.
Absolutely. Yes.
That's what I wanted to say.
Yes.
In my son's case, CAIR tried to get involved. They contacted the Federal Public Defender's Office. They wanted to go and meet with them, and speak with them, and give them a better understanding of where what is way. I think, because they don't know. I didn't understand this song, but they would. She even brought them a book. She even brought the public defenders a book written by Trevor Aaronson,
Yes.
and they pitched it in the garbage, I think. The federal, what they wanted to do was downplay this Islam. They wanted him to denounce a religion because the court would go easier on him. And he refused.
It's a shame. Where was this case?
In Cincinnati.
Yeah.
But I mean, Karen did reach out. I still talk to Karen.
Karen the Duke, yeah.
Yeah, I talked to Karen
Yeah.
quite frequently.
Yeah. One thing we've tried to do is we've tried to get Trevor Aaronson out into more communities to educate about this program, because the more people are aware, then the more people we can prevent. You know, and I tell everybody, listen, you know, keep your eyes and ears open. Somebody comes and talks to you about troubling things, you know, they're most likely, you know, they're not good one way or another. And we need to have an open dialogue and know about those individuals, because more often than not, again, they're either a corrupt person trying to corrupt you or an informant trying to set you up. Either way, we need to tackle them before they corrupt our youth. You know.
In the last few months, a few judges and at least a couple of juries have started to look at the cases differently. So the cases we call preemptive prosecution because none of the people have actually done anything that's harmed anybody, right? It's all out of fear of what might happen in the future. What I would say is a generally irrational fear. And some judges have started to no longer look at it that way, to started to not be kind of under that spell of the fear. And so it happened in 3 newer cases and in a couple of old cases. So one of the cases where a couple of people recently got released who were they were sentenced to life. It was in the Virginia paintball case. Saifullah Chapman and Masood Khan, they were sentenced to life for going to a training camp in 2001, around 2000, 2001, and firing weapons at a training camp, never actually harming anybody. Back then, they were convicted under this firearms law, under a statute called 924C, and the definition was if those firearms were used in connection with a crime of violence, they could get these life sentences, basically. And the definition of crime of violence was that there had to be a substantial risk that physical force against a person or property would be used in committing this offense. And at the time, the law required that that definition had to apply in these cases. And so these guys were sentenced to life just for firing weapons in the training camp. Now, that was a long time ago. They served over 10 years. And then last April in 2018, the Supreme Court decided a case called DiMaia, which involved this same exact definition of crime of violence. And they said whenever a court uses that definition and applies it without looking at the actual facts of the case, which is what they were doing. They were just saying, we're not going to even look at the facts, we're just going to say that all these things are crimes of violence. They said, you can't do that. That's unconstitutional, it's too vague. How can the judge know whether there's a substantial risk that force would be used or not if they don't even look at the facts of the case? So then Masood Khan and Saifullah Chapman filed these motions saying, well, now we were sentenced to life based on this same definition that the Supreme Court said is now unconstitutional. So it went back to the original judge, Brinkema, and she eventually said that she was looking at the DiMaia case, and she decided that she was going to look at the facts of the case, which they didn't used to be allowed to do. And she looked at those facts of that training camp, and this is really important. She said there was no substantial risk that they would use force, that they were just at a training camp. There wasn't like this risk that they were probably going to go ahead and fight and kill people or anything. She said there wasn't, and that is a counter to the narrative of preemptive prosecution, right? Because the whole idea of preemptive prosecution is they're saying, oh, there's this risk that they're going to do these real attacks in the future. And she said no. After all these years, she said no to that, and she let them out. And now the government's appealing, but she made a pretty good record, and they got out, and it's wonderful. Now, unfortunately, that is not going to apply to the other cases because it only applies to these gun cases under this particular law with the 924C and the particular definition. But the concept eventually may be able to apply to some newer cases where you're arguing there's not a risk that this is, why are you going after all these people in sting operations based on this risk that something might happen in the future? It's the same concept, and say there's no substantial risk. And eventually that may be able to help in some of the newer cases, and then they may be able to be applied, because you can't apply it to the older cases now. You have to have the law change to apply to the older cases first, and the only way to do that, one way to do that besides going to Congress and lobbying is to raise these issues in the newer cases where because you can't reopen, it's so much harder to reopen older cases. Anyway, so it's a hopeful trend, but it's not gonna help right away, but it's definitely a positive sign. And then there's some of the newer cases where judges have been looking at it differently too. Some judges, it's just starting. So there was a guy named Bakhtiar Jumayev in Colorado, and he was charged with material support for sending a check for $300 to a co-defendant, knowing that it was going to go to a designated terrorist group. And the government was asking for 15 years, which was pretty typical in cases like that. But the judge, now this guy had been held for 6 years pre-trial, and the judge looked at it and said, you know what, that's enough. I'm giving him time served. So he got out. He got out. And he said the government request for 15 years was absurd. He said, this is what the judge said when he did the sentencing. He said, we must recognize that a human being is the focal point of the sentencing process and should not be ignored or dismissed because of the inflamed rhetoric of the war on terror. I am reminded by Judge Learned Hand's wise comment, if we are to keep our democracy, there must be but one commandment, thou shalt not ration justice. So that's what he said. So that we were never seeing anything like that in these cases before from the judges, right? So step in the right direction. And then there was another case in New York City recently. There was a man who had actually gone and joined ISIS in Syria in 2014 and spent several months there before he became disillusioned right away. But it took him a few months before he managed to escape, because it's not that easy to walk away from that. And the judge in that case was this 93-year-old judge named Jack Weinstein in the Eastern District of New York in Brooklyn. And he wrote like an 85-page decision. This guy's amazing I don't know how he can do it. I'm 55 and I don't have the energy this judge has at 93. But anyway, he actually redacted the defendant's name because he knew that he would be subjected to threats and harassment if his name was out in the media. But he let him out. And he said, this is the beginning of his opinion. He said, terrorism in support of ideology is not unknown in American history. And then he cited to John Brown, right, who led the raid on Harper's Ferry. And he said, nor is the history of export of American volunteer fighters to foreign wars unusual. We need only recall American individuals' aid to civil wars in Greece, Israel, Italy, Spain, Sri Lanka, the Soviets, and Nazi Germany. So basically saying, this isn't like some totally unheard of idea of people going abroad to fight in some group that's not even attacking the U.S., right? Like, why are we treating these cases so much harshly than we ever did before? And he went through all these factors, and he gave him time served. And this is a guy who had actually gone and joined ISIS and come back, and he totally renounced it because he realized what ISIS was actually doing. But he only got 21 months, and it was time served. So another very positive sign. And then there was another old case who just got a new trial. Uzair Paracha was charged with material support to Al-Qaeda, again in New York City, in 2003. And this was based on him having helped a guy in Guantanamo named Majid Khan. He just helped him obtain legal status in the US. So the question was back then whether he did that believing that Khan was a member of Al-Qaeda. Because if he didn't know anything about that, it would be a really minor immigration fraud charge, or he probably wouldn't have been prosecuted at all. But because of the climate of fear back then, he was found guilty at trial of having knowingly supported Al-Qaeda by helping this guy get legal status in the US, and he got sentenced, Uzair Paracha got sentenced to 30 years. In 2008, he filed a motion for a new trial based on new evidence, which were statements from the guy in Guantanamo, Majid Khan, and a couple other people in Guantanamo, and they said he didn't know about Al-Qaeda, the Al-Qaeda connection here. This was his nephew, I believe, and he just was helping his uncle, and they said he didn't know anything about Al-Qaeda. I guess what happened was these guys had been tortured, and under torture they got them to say, oh yeah, he knew about it, but then it came out later that was under torture, and they said no, he didn't really know about it. And now that motion was filed in 2008, and Rachel was talking about the motion that's been pending for 2 years. This motion was pending for 10 years, from 2008 till 2018.
Why does that happen? Does that just sit on a judge's
Because there's no law or any mechanism to make them decide it sooner, I guess. I never heard of it lasting that well. Sammy's case, it lasted a really long time too. But so February 2018, oh, you know what happened? From February 2018, the guy Uzair Paracha in prison filed a handwritten motion called a mandamus motion, which is asking that the judge make a decision. Just make a decision. It's been 10 years. Just make the decision. His lawyers didn't do it. Probably lawyers are afraid to do that because they think that's going to piss the judge off. He did it. He finally got fed up. He did it. The court granted the motion and gave him a new trial. So he's getting a new trial, and hopefully we'll see what happens. But that never happens in these cases either. You never get the new trial. So that was really good too. And you also almost never get bail. There was a guy just a couple weeks ago, a guy named Adam Shafi. He was charged with attempted material support because they said he was trying to join al-Nusra in Syria. He spent 3 years in pretrial detention, and he just got released on bail. Actually he had his trial, and this is another thing that usually doesn't happen, is there was a mistrial. He had his trial, and the jury voted 8-4 to acquit him, but it has to be unanimous, so that's a mistrial. There can be a new trial, but meanwhile, he got out on bail pending that new trial, which also almost never happens. And then the other recent case was the Noor Salman case in Florida, where she's the widow of the Pulse nightclub shooter, and she was acquitted. And the government committed a lot of misconduct in that case. It was talked about last night. So there's several signs that we didn't used to see of positive, although there were a few victories in Florida before, but very small percentage, and we're starting to see a little more. And so we just need to keep educating people about this stuff. And the other thing is that was mentioned last night is that because of all the resistance to Trump, people are starting to embrace Muslims as part of the resistance and part of the communities that are opposed to Trump. And so it's possible to work with other groups like FAM and get other allies with groups of people of color, Black Lives Matter, and Latinos, and just try to really build those alliances and try to keep turning that narrative away from just that total irrational fear. And because, we can't just do it with the law the way the law is now, we really need to change the consciousness. So I'm seeing some signs in that direction. So I'm very more hopeful than I have been over the past 10 years or so. So thank you. Can we, I think I want Steve to go, and then we'll have questions for the three of us.
I'm just going to be very brief. I'm just going to pick up on what Kathy and, actually everybody is saying, that you go through a period of a drought. You think of a drought, and the land becomes parched, and the lakes dry up, and there's cracks in the soil, plants die, there's just this beating sundown, and you think there's never going to be relief. And then one day you get up and suddenly there's a cool breeze from off the mountain. You feel something has changed. Somehow something is coming. It's not rain, it hasn't started to rain yet. But the way you look at the weather, you're saying something is coming. And that's what I'm feeling now. I'm feeling it in the cases that I'm seeing. This isn't rain yet. This is technical stuff. People are tweaking things and moving things around on the court. But the court is starting to say, look, let's not get irrational about this. We've been having irrational fear for 10 years, or more. We can do things differently. And I'm feeling it in you people, all of you. I'm so very, very proud of you. I think back to the first family conference that we had, and people came in and the atmosphere of fear was just crushing. Nobody wanted to talk. Everybody was scared. Nobody knew what was going to happen. And slowly I'm watching how you've evolved from a group of people that had just been dealt this tremendous blow by the government into a group of people that can talk openly about it, who are assuming leadership positions, who are moving ahead. And that's part of that cool breeze coming off the mountains. And we have to keep that moving. That is really important. You are part of the rain that's going to end this drought. That's all I wanted to say.
Yeah, well said, Steve. I also was super impressed by everybody's stories this morning. It was really intense, but we got some great storytellers here, and that's going to help push the change, like everybody was talking about. So I guess we'll have questions. Oh, Rachel, well, we're going to open it up for questions and answers, and I'm going to turn this so Rachel can see all of you, and you can kind of see her on the laptop here. And so you can ask questions to any of us, or just a general question. Should I?
And Kathy, I'm having trouble hearing the audience, so if folks ask questions that I should answer, can you just repeat the question for me?
Sure.
Or take the microphone around.
Oh.
That might be.
So we had.
Like you said about those cases, something positive happened, even though those people actually didn't act, but they still released. And half of our cases, when people didn't even act on it, and they are serving 30 years in prison, 68 years in prison, or life in prison. Can we do something like motions like right now the prisoners are doing in there without the lawyers' help? They are writing their own motions right now to the judges, so to review the case and to lower the sentences. Like my brother is trying to do something, like sitting in there thinking about like I cannot take it anymore. I wanna be released. I didn't do anything. So can we do something like guide the prisoners to write their side of the story, and just like Kathy said in Brooklyn, one of the case where he wrote a motion and keep writing it, and one day the judge actually wrote for him, not against him, and he got released.
Yeah, you have to have either new evidence, like that guy had new evidence that came out of the Guantanamo reports. You have to either have really strong new evidence, or you have to have a change in the law that applies to your case. So most of the cases, unfortunately, don't have either of those things. Sometimes you can apply for compassionate release, but you have to be over 65 years old to do that. So, each case is different. In many cases, there's not a real legal mechanism right now. But you can still write up your story, and we can send them to FAM and try to get them on their website and do all the advocacy and hope that the law changes or you find new evidence. But in many cases, I don't know that there's a good motion you can file. I don't know. Anybody else wants to add?
Yeah, I agree with that. Right now, we're still in the period where the courts are saying, look, we're going to start maybe, possibly some judges are going to start looking more compassionately at the cases. But first they have to come before me under some legal theory. And most of these cases don't have a legal theory. That's the problem. Here you had a change of the law, the Demaya case. Over here you had some new evidence. But each case is different, and there's not a generalized attempt to review these cases. That's what we'd like. That would be, I hope, the next step of forcing the courts generally to review all of these cases. For example, if you took material support for terrorism and said there has to be an intention to be violently attack certain groups, that would open the whole thing up to review in a lot of these cases. And if the courts are inclined to act somewhat more compassionately, they might use that as an excuse to get rid of sentences that they think are shock the conscience.
Yeah, so if we had a bill to do that, it used to be in a bill the ACLU was pushing to change the material support law. If a bill like that we could get passed, then it would affect the new cases, but we could also make it retroactive, hopefully, to get people out who got convicted of material support already without the proof of actual violence being involved with it.
Actually, I think now the judges are feeling these cases are, I'm sorry, it's a fake cases now. That's why they're not wasting their time and, all that to, give someone long sentences. They're just releasing them. So maybe there is hope.
The other thing is for entrapment, we can change the entrapment defense so that there actually is an entrapment defense. That would be another bill that we could maybe someday get passed that says that they have to actually prove that the person was doing something beforehand or that they were actually predisposed before the informant came and started showing them all those videos, right? And if we change that, same thing, it could help the new cases.
Like a person didn't went to and the person coming to him.
Right. So to try to change that law, but the law has to change first. So, does anybody else have a question?
Yes.
Back there, can we pass the mic back there?
Our mom, she said, why we can't file a case against the FBI according to the new evidence, how they make it up, like last weekend, that's driver and limousine car, and his informant, like how they trap the kids. So is this thing's possible, I think, or?
Well, she's talking about how the informant in our case, Shahed Hussein, he's a really terrible person who the FBI enabled since 2002 or 2001. He was committing fraud at the DMV and he was facing a long prison sentence and deportation to Pakistan. But instead, the FBI hired him to go after Yassin Araf and Mohammed Hussein, who were totally innocent, and make this case against them. And he lied and lied and lied, and he even lied to the FBI. And then we thought, okay, well, they got convicted based on secret information, etc. The FBI is probably not going to keep using this guy because he was even lying to them. Well, they did keep using him. They used him in the Newberg case where he was even worse. He committed perjury so much in that case that the judge knew he was committing perjury. She told the jury he was committing perjury, and she wrote a letter to the prosecutors up here and said he committed fraud in your bankruptcy proceeding up in Albany. They ignored it. They kept using him even after that in a case in Pittsburgh where he destroyed the case. It became an Emmy Award-winning documentary called T-Error. You can find it on Netflix. And he kept getting away with everything, every step of the way, and got hundreds of thousands of dollars from the FBI. And just about 2 weeks ago, we learned that there was a horrible, horrible limousine accident near where we live in Albany, the worst accident since 2009 in the whole country. 20 people were killed. Everybody in the limo was killed, and 2 pedestrians. And we found out that he owned that limo company and that it had 1 million safety violations, that he was told he had to take that limo off the road. He was enabled by the FBI to ignore any laws, any rules. They don't apply to him. He kept committing crimes and fraud, and it cost 20 lives now. So this is coming out in the media. We kept pushing the FBI angle. We can't sue them because they make themselves like almost impossible to sue them. and maybe Rachel can talk about how hard it is to sue, but it's coming out in the public, and the FBI was forced to say something. Of course, all they said was, we don't talk about our informants, but the reporters kept going to them and asking for a comment. It looks really bad for them. So, I mean, Rachel, do you want to say anything about suing the FBI and why that's difficult, or if there's any possibilities there?
Sure. I mean, it's incredibly difficult to sue federal officials who violate the Constitution. Unfortunately, there's a way to sue state officials who violate the Constitution or who violate the law, because Congress passed a statute that allows people to do it. But there's not a law like that allows you to sue federal officials. The Center for Constitutional Rights has a case that has been going on for many, many years that we filed after 9/11 to try to sue the federal officials who were responsible for, rounding up all these Muslim and Arab men after 9/11 and treating them as suspected terrorists based on nothing but their religion and ethnicity and immigration status. And so we tried to sue for damages these federal officials who are violating the Constitution, are putting people in prison in solitary confinement based on religion and nothing else. That violates the Constitution. And unfortunately, the Supreme Court decided last year in our case that you can't sue federal officials for unconstitutional policy. If there's like a one-off action, that clearly violates the law and it's not part of government policy, sometimes you could sue for damages about that. But if it's a governmental policy, even if it's clearly unconstitutional, you can't try to hold those federal officials accountable. Unfortunately, I'm going to have to go. My children are going to come back in a few minutes, and I don't want to disrupt everything that's happening in there. But I'm so glad to just be able to, be in the room with you all, even remotely. And thank you so much for all the amazing work you are doing, gathering together and fighting together. It's really inspirational to all of us who do this work. So thank you.
Thank you so much, Rachel.
Can I ask you one question, please, before you go?
Sure.
Yeah, my son, he's a victim from NYPD, and I live in New Jersey. And I just read article about one guy, his name Hassan Faraj, or Faraj Hassan. He was a police officer, and after that, I don't know what exactly happened with him. They put him into prison. Then he lived in New Brunswick, in New Jersey. He made case against NYPD because they're not supposed to follow anyone from New Jersey. And he won the case, even they pay him $350. My son, he's victim from NYPD. Why they arrest him? And why they put informant from New York to New Jersey? My son, he doesn't do anything. They spend to arrest my son $250,000. Even the guy who used to follow him, he died before they arrest my son 3 weeks. So when they arrest my son to make him happy in his grave, they put his chain on my son's hand.
Yeah, I'm so sorry to hear about
then
that.
Then they said like Dimaya is helping, so why they not open all these cases from New Jersey for my son and his friend? My son get 22 years and in the courtroom there is nothing against him. Or only Muhammad purchased a flashlight to use it in Al-Shabaab in Somalia to kill American. There is no American in Somalia.
Yeah, so I'm not a defense attorney, so it's not really my area of expertise. I wish I could be more helpful. I don't know if your Steve maybe can be more helpful to that question.
It was a sting operation, just like the other sting operations. So whether there was surveillance going on that was illegal, it doesn't really change how that is looked at legally. As far as it's a sting operation, they're all very unfair. The informants push the people to say bad things or try to do bad things because they get manipulated by the informants, and they're all very unfair. But that case about the surveillance, I don't think affects it. Plus, it's difficult because he took a guilty plea, understand?
Yeah, it's his lawyer who encouraged him to be guilty. That's what he told him. He told him, if you plead guilty, I'm gonna bring you 8 years, but my son, he wasn't lucky. In the same time, in the same second, when he was in courtroom to sentence him, Boston is bombed. And the judge, he received letter from the FBI, and after that, everything is changed. I know he gonna serve 8 years only. He's supposed to be home now.
Yeah, that's another problem with federal sentencing is.
So why my son, he paid the price for all the terrorism in the world, for all Muslim? That's not
They're
fair.
all very unfair cases, what can I say?
They use the tactics.
So there is no kind of mercy because he's the only son I have. I don't have children.
Yeah, I'm really sorry. Anybody else? Can you pass the?
I'm going to say bye now. I have to leave, but thank you all so much.
Thank you.
Thank you.
I was first.
Yeah, I want to ask a question. While Emmanuel was convicted and he went through his trial case, he found a lot of things in there. And he wrote a motion for a new trial. The lawyer,
He went to trial and got convicted.
right, he got 20 years, and they're appealing because he pleaded guilty, as you said
Wait,
earlier.
oh, he didn't go to trial?
No, he didn't go to trial because his lawyer told him, if you go to trial, most likely you're going to get 63 to 100.
Which is
Yeah,
unfortunately
so,
often true.
right. And if you plead guilty, you'll get, he was saying 10 to 20. But when they sentenced him, he got 20. So he went through the paperwork and everything, and he found a lot of errors in there. So he spoke with the lawyer to do with the appeal, and they did find some things in there, and the lawyer filed an appeal, and they just had the, what do you call it now? Arguments?
The oral argument?
Right, so now they're waiting to hear from the judge. So
That's in the Second Circuit down
Yes.
in New York City?
Yeah, in New York City. Do you think he's got a chance with all these changes that?
Maybe. I mean, I can't say without knowing the particulars of that case and that appeal. And oftentimes people can't even really appeal because when they plead guilty, they have to give up their right to appeal,
Right.
which is another really unfair aspect of it.
Yeah.
But sometimes there's ways around that in a particular case. So I can't say any. And that's the other thing about federal sentencing is when you plead guilty, usually you don't know what sentence you're going to get. You know kind of like what the guidelines are probably going to be, but you don't know what enhancements they might put on there. So you're pleading guilty kind of blind. Sometimes you can plead guilty to a particular number, like I think Umayma's husband maybe did, but right. But usually you don't have a particular number. Unlike like state court, you usually know.
Yeah.
In federal, you don't. So it's really hard. And they'll say if you get less than like 30 years, you give up your right to appeal. And if you get more than 30 years, then you can appeal that sentence. But it's really hard. If you get within a certain range, you don't even have a right to appeal usually. So hopefully he has the right to appeal and did appeal and got to the oral argument. So hopefully he can get some relief.
So I'm just praying it to God to, that the judge will see, and grant the appeals for new trial. Grant,
Yeah, so on the appeal, it's like usually 3 judges that decide together. Yeah. So good. I hope that there's a miracle there or another hopeful trend.
I have a question about the Maya. How you can know that it's applied in the case or not and who make the decision for that, and how you apply for that?
So DMIA only, it applies to almost none of our cases, only a couple of them, because it only applies to people who were convicted of gun charges under a particular law called 924C, with a particular part of that law, with that definition of crime of violence. So it usually doesn't apply directly. I looked at our cases and there were only a couple.
How you can get these rules, you know?
What?
The rules applied in the Maya, how you can find it?
Well, you'd have to know what the person was
Yes.
convicted of and see if they were convicted of a 924C gun charge for possessing a firearm under that particular definition. So yeah, that's what you'd have to know. You can write to me and I can check, but usually it's not, unfortunately. In the Fort Dix case, two of the Duca brothers, and I think maybe Mohammed Shah, did he have that too? No. Did he have the gun charge too, or just the stupid conspiracy?
I think it was added, but we were able to take that one off.
You got that one off. So it's two of the Duca brothers. They all got sentenced to life, and some got the extra 30 years for the gun charges. So the only thing we could try to get rid of with DMIA there is the extra 30 years, and they still have the life sentence for the non-existent conspiracy. So it's really still a huge uphill battle, but we got to take the little hopeful signs when we find them and try to push them to make them bigger.
Okay, thank you.
Yes.
Yes. I remember when my son was going to court, his attorney just kept after him. I mean, every visit, cut your hair, shave your beard. You know, they didn't want that. You go to court looking like that, you're going to get the 30 years. If you clean yourself up and you go and look presentable, what they consider presentable, you know, we're looking at maybe 10 years for what you did, 5 years for being stupid, for doing this stuff after the fact, after he was already incarcerated. And I mean, you know, they know these court. They know that there's already discrimination. You know, the public defender. I mean, why would you have someone denounce their faith? You know, when he's devoted his whole life to this, he was dedicated.
Yeah, they don't usually do that. In that case, I don't know. They were trying to help him, but it's kind of a strange way to help him.
Yeah, I mean,
and it didn't help him because he still got 30 years, right?
Well, he did shave his beard. He did shave his head. He went to court, and now the doctors, I mean, they were going to find him incompetent to stand trial, but because he did that, he never denounced his religion. He just shut down. And but they explained that, you know, he was still very vulnerable and that he could go back at any time. And they never took any of that into consideration. I mean, they looked at him and, you know, he looked like Mujahideen, you know, when he went to court. But why? I mean, they just discriminate. And the attorneys know this, and like I said, you know, they worked on him for almost 2 years just to try to get him to shave his beard and cut his hair and denounce his religion, which he's dedicated his whole life to. And I support him 100%.
And that's another thing where the law needs to change is that, I mean, he has a lot of mental illness, and that was a major factor here why he was vulnerable to the informant. That should be illegal. They should never be able to target mentally ill people in a sting operation. They shouldn't even have sting operations, but if they're going to have them, they should definitely not be able to target mentally ill people or people who are particularly vulnerable to that. That needs to change too.